for few past days or months no yin na yin hunu e koso court. It's all about to force the case the ambulance saga. You know, information keeps unfolding in sena ba neba na enunti nyame adom ochina court court na sibio was a case we are to be the ambulance saga. Na was a court na se was obi a preparation towards court trials or court, and you know Godfrey the Adame on the attorney general or also etna case we so for the MPP party. And this case no the pay my very interesting. Yankasa mame Yankasa justice, the chief justice Sewa Saribuchi on a appeals court, but this time no say as the high court judge on this criminal case about the ambulance saga. And this is no your boy Adame so the attorney general in who jumedi papa and no ne nyame adom ochina and omokwa kushia. Anti nsam na kwakoye bebre no omkwa kopemu our court ready information ba na we akwakoyi we yefria say omo file say omo yi bibia possible bia be say ne ho kwakodim Richard Jakpa the third accused the main man ono and I say when na this obo no ebono Dr. Keso ato forcing ono so na the first accused and na Sammy Gyamfi the legal team ono so eboa ama bibia akoso 13 ama yankase papa the minority leader in parliament Dr. Keso ato forcing and sisia no NDC for nani abre and na the attorney general ono so nani abre pa because yenyina ayehu few months HME yehu nsema ode ba bonti chese wama NDC for hu atwo BNI for do mo agim law professor bi so bai becheche you know nsem chese you know contempt of law nyina abem nsem Sammy Gyamfi kokan the legal team or supporting Dr. Keso ato force chese you know sisia no objection overruled and na abasisia it is for case no why you very interested but also benya botre na benya ndaje na obuhu ne ekoso about this case particular case the ambulance saga Dr. Keso ato force uwi nso abeso say ma refi so be subscribe to Ordinary TV or be like or comment your comment section uwi nso or click on the notification button for more news updates na ebusiafo you know de boa ema nipa ho ne ekoso ewe ye man Ghana ma se obehye unya bia no ama unya bi nti se won saka link we ya nkwa won hwe sa nyankopon kwa won show so the obetimi aya and say you are going to share this link you know to many people as many as you can na mo so be hu ne ekoso ewe ye man Ghana ma se ye che won egoti nsema ekoso emersisia bidas
kura the ambulance saga nyame yandoma uchina ena court etna at the registry of the Accra High Court. Godfrey Adame, Attorney General in the office. Richard Jakpa, third accused. Dr. Keso Atoforsen, first accused. Sammy Gyamfi, NDC legal team. Nenye easy wo hono mokra. And the Nekokosi or Accra High Court Registry, applications upon applications, and the way filing, now is what filing, where the two, now with the tomb, where the shoe, now with the shoe. And SMPTV and Saka applications and then you're filing the registry of the Accra High Court, and Yamiya Doma China, Justice Efia Sewa Saributri, our Court of Appeal judge, no, and as a criminal trial or Tanaso. As a high court judge, about be pinning him a man at Tenassi. Now, what determine said the case now, ABC Aquacusi. Now, I shall seem free a year or case after forcing a shade because on the home a care dream near her and Umrea, the only Sammy Gyamfi and the NDC legal team or the Aquacushim a court registry. Now, this is from lawyer Sammy Gyamfi Esquire. I say lawyers for Honorable Ato Forsen have filed a supplementary affidavit in support of the motion on notice for an order of mistrial, injunction, and or stay of proceedings in the ongoing ambulance case. And just say, Niama miyansa, applications in yansa, and Honorable Ato Forsen pray Justice if you are in the court to send number one, an order of mistrial. Now, an order of mistrial in SMPTV. Any lawyers video come on and say an order of mistrial now at a force in court and granting. This is what it actually means. Now, a mistrial occurs when a jury is unable to reach a verdict, and there must be a new trial with a new jury, or there is a serious procedural error or misconduct that will result in an unfair trial, and the judge adjourns the case without a decision on the merits of the case and awards a new trial. Now, just say case at force any NDC Richard Jakpa almost say Justice if you say was application we can find last week concerning Nyama or more few say Attorney General Aya misconduct na prejudice case no tinebea asem no kra no trial de novo yen chance foforo judge oteso no yen sesa no fa new judgment na so yen constitute panel na o beti asem no yen san ko chance yen ka asem no right from day one with a new bench, a new judge, a new prosecutor. 1% go for the about damning and a better case so I feel almost also a seeking an injunction on maybe a seminar could do yenya can copum say be determined some I think so a stay of proceedings. I just say every other be a judge na aye piano yen train so na all the accused persons you may be on person mu di bia yenya omo na omunyi say jumedi na omo person omudi no. Now, and the office of the Attorney General, and also a dignity called Tum, or someone Krokran and Moody, on Penamamo, and Mamon filing applications with National Courtisia, more family disrupt to case. Now, the office of the Attorney General, and so add the application to now, also application, Moko to also, and some more on the 2 journey. Almost say affidavits filed in opposition to the applications before a high court in Accra. That the accused persons are bent on using any means necessary, fair or foul, to abort their legitimate prosecution for crimes committed against the Republic, must not be aided in that illegitimate endeavor through a grant of the instant application. Like I said, the Office of the Attorney General also says, "Some no make can no boa, o me di bone." I was here do mo famara kwan so, and some mo make can di ni na so bia nti ni kwan se court no. Now, the office of the Attorney General also affidavit in opposition. No, it avers that it is in the public interest that the case be brought to a firm conclusion based on the credible evidence before the court. In the particular case of Dr. Forsen, the affidavit in opposition argues that continuing his prosecution to its logical conclusion will uphold the principle of equality of all persons before the law and defeat the perception that the powerful and politically connected can get away with crimes on account of undue pressure and false allegations. And she said, the Office of the Attorney General still maintains, say, the sitting trial judge has already established a prima facie case against Forsen Richard Jakpa. So, omo won some also be yano. Ninti no mo file statement of no case or bototwene no say evidence here dia better court no dia dance here. Say letters of credit are issue here. Car somebody buy say ambulance. You rejecting the Ministry of Health. It is clear say there has been a certain kind of loss to the Republic of Ghana. The Office of the Attorney General in their affidavit in opposition and was stating it clear. Says a court no etie in someone Sammy Gyamfi to force no lawyers say they should conduct a mistrial or chance for or for injunction to some state proceedings now. The Rama Ghana for adjoining in Ayom say if you are connected politically there and you want some intimate say the Mahama debate to you so munya to force in case now. Otherwise the minority will not comply in the business of government no. And I just say yeah you know correct. So the trial judge, Justice if you are the office of the Attorney General also affidavit or file and say she should not accept a yes applications here or more day abe. Now, same way now the Aquaco Faba yes leak tape recordings and semia the NGC is alleging say the Attorney General and Richard Jakpa Eddie Komo say on can be to implicate at force near finding Congo tomb into professional misconduct or criminal trial ɛkɔ so no ɛna attorney general ɛde ne ho afɔrofɔro nti wasɛe asɛm no nyinaa. Now lawyers from the opposite side and the woman to San Simu, Professor Kwame Jan, a lawyer ni papa, Brenim ni Kesiepa, and one lawyer from the NDC side, lawyer Pia. Omunina Adjuna Kwadrin Krumu on this same issue. Professor Kwame Jan states categorically clear, say the office of the Attorney General enye boni bia so ne Richard Jakpa din komo. And komodi ne koso there was nothing in the shape of implication and no force Richard Jakpa say one can be and fentia Iura ato forcing. Now lawyer Pia so on the NDC side and so chere say ono dear a dear we are no anga party for you no hu nyina so bi omo because tape na mo de aba no one afei na mo de court it is going to be tested on two things based on relevance. How relevant is this audio recording in the case before the court now? Ebeka ye no na justice fias ras mu tube kan so no de mo kekan de onte niam e won ni mo court and odi be ye adwuma. That is number one. Number two, also say it is going to also be tested on admissibility. Admissibility na se begia to mu a age say am pass it through certain tests bi age say ahwehwem ehunu say ampa tape no original. Ebeka ya in the election petition case where MPP present here over 11,000 pin sheets. On the case of admissibility, the test for admissibility, no, the KPMG audit, ama yi bebrebe free mu, and sana the catch, no, yababe admitted a use no court. In the same way, that audio must be tested on the basis of admissibility. And to win yes, I am a den na file supplementary affidavit application, say young conducting mistrial, young grant to injunction, any stay of proceedings. Tomorrow promises to be a very, very, very eventful day in this ambulance case trial. Now, when we call into lawyer see or manu this concerning this new development in the autoforcing case.
Investigating a crime or suspect that a crime may be committed, they would go to a court of competent jurisdiction and seek leave of the court and obtain same and tap into your communications with leave of a court of competent jurisdiction. In that situation, admissibility should not be a problem. In other situations, our law, if you go back to our evidence decree, the evidence decree, which is now the Evidence Act, because of the Statute Law Revision Commissioners Act, is one of the best pieces of evidence decrees in the world, or evidence legislations in the world, because the drafters, led by a late Court of Appeal justice called Justice Ofori-Boateng, famous judge, they studied the evidence laws of almost every civilized jurisdiction and tried to find out what is the best practice before they created our own system. Now, in American jurisprudence, there's a principle which is known as the fruit of the poisonous tree. It's one of the principles that applies in the law of evidence, which says that where a tree is poisoned, the fruits of the tree are also deemed to be poisoned. In non-legal format, it means that if evidence has been collected in a way as constitutes a violation of law or rights recognized by law, the evidence will not be admitted to establish the guilt of an accused person. But you made a point. There are circumstances under which that evidence may be admitted. And in fact, in the case of Raphael Kubaji versus Michael Yeboah and two others, the Supreme Court set out the parameters of admissibility and made provision for the evidence to be considered on its own merit, depending upon the gravity of the offense that is on the table. So the courts have a way of dealing with it. But the general principle is that where the tree is poisoned, the fruits are also poisoned. That's the general principle. But like all general principles, there are exceptions. There are exceptions.
Right.
But the exceptions don't become the rule. They remain exceptions.
Talking about these exceptions, are you able to elaborate further whether there are legal distinctions between recording a private citizen and recording a public official, as has happened?
Honestly, our laws from the constitutional framework through statute and case law, our laws have not distinguished between how you treat conversation with a public official and how you